Good evening, Michael. We're live. How are you going today?
Good, thank you, Shane. How about yourself?
Yeah, good. I was just sort of pondering as I was pouring myself a sparkling water from my fridge that it's been, 4 or 5 months since you and I met, and how it's quite normal now to fire up StreamYard and get online and talk about this stuff. Whereas I remember the first little forum we did together, it was like being in, I imagine how it would be living in space. It was all extremely peculiar, and you didn't really know what's going to happen next. But it's become, as much as I hate cliches and some of this language that we hear used during COVID as the new normal and unprecedented and that, but it really is the new normal, isn't it? Getting online. I
You're
fucking
right.
said it. I said it.
It,
Yeah,
it's
I
funny
regret
how
it immediately.
that whole thing about habit. Like it's funny how you do something and you just get into the habit of doing it every week, and suddenly you look back and you've done it a whole lot. Um,
Mm.
and it is true. It's been quite a while now that we've been doing this.
Yeah, no, it's really, really good. I was talking on another webinar today. My friend Colin Gitley was kind enough to have me on hers, which is of a bit of a different nature, but to gen people up who have been through redundancies and having real difficulties, maybe having been in a highly paid, coveted job such as pilots and having no demand anymore for pilots, or reduced demand, and having to turn
Mm.
their hand to maybe less decorated pursuits and swallowing their ego and dealing with a bit of depression and
Well, to chip,
loss of self.
yeah, out
Pardon?
we've got we have a farm just out of town, and the
Yeah, and um, talking to just Colin this morning is just just made me realize that um, and yeah, I speak for you as well, Michael. We really are in a privileged position to have not been. I mean, we're affected and you're affected, but
mm,
not been really drastically affected by it, and to be really grateful for that and do your bit to maybe give back a little bit or be helpful to people and kind where you can, because not everyone's been so fortunate. Which just brings us to the next kind of peculiar adaptation of the economy to this whole mess is the absolutely fervent growth and almost rabid take up of residential lending and purchases. And we're not going to speculate, because we've already done that a little bit, about why that is and whether it will last. But we are going to talk a little bit tonight about the process for buying and selling homes, particularly focusing on buying tonight. So you hear, and whether there is wisdom in it or not, you hear that it is a good thing to look at a property at the moment because of interest rates being historically low. You make a phone call to the local agent because you've seen their better than average advertising on a billboard outside a property you quite fancy purchasing. We thought today we'd just give a little bit of a sort of précis or summary of what happens in quite simple terms. And if anyone wants to understand further exactly what to do, contact Mike or I, and we can steer you to the appropriate people. So just starting off, you call the agent, you get all excited, you want to put an offer in, say there's an auction, a pre-offer on the property. So the agent will, if they're any good, well, in this day and age, will provide the Auckland District Law Society sale and purchase agreement for you. And that agreement has a series of conditions. Conditions, pro forma conditions I'm talking about: finance, builder's report, limb report, toxicology report. I think that's it off the top of my head. I don't do a lot of conveyancing personally, our firm does, but I believe that is it. You have those conditions, and what conditions are uh, events or circumstances. Can you hear that strange noise, Michael? Is that coming from you or me? It's like a bird chirping.
I think that's on my end. There's not much
I
I can
think
do
it might.
about
No, there isn't. Like, maybe they objected to the boring subject matter. So a condition is something which the agreement is conditional upon before you have an unqualified or an absolute obligation to complete the purchase. talk about the finance condition. The finance condition is expressed as you are to do everything reasonably necessary to obtain finance to purchase the property. You can express different levels of the level of finance required, but it's usually just expressed as something along the lines of sufficient to complete, which convention has it, means once you've paid, come up with your deposit and maybe put your KiwiSaver in, you have sufficient finance to complete the purchase. The latest Auckland District Law Society agreement actually provides that if you're going to terminate or get out of the contract for failure to get finance, the vendor has the ability through their lawyer or directly to ask for proof that you did not actually get a finance approval. That's to stop unscrupulous purchasers or purchasers who perhaps have had buyer's remorse and think they are just going to tell a white lie or a porky to the vendor because they've changed their mind about the property, they've lost their job, etc., etc. So a finance condition is not a condition which gives you a protection under all circumstances to get out of the contract just because you don't want to purchase the property anymore. If you want something like that, you need a due diligence condition. Due diligence condition has a widely accepted meaning whereby, and the clause should ideally be drafted to make this explicit, but it has a widely accepted meaning that you can make your own investigations about the suitability of the property for your purposes. And if you cancel the agreement under the due diligence condition for non-satisfaction, you're able to walk away without any questions asked. Just make a quick point here that is distinct from a solicitor's approval condition. The solicitor's approval condition is conditional only upon your lawyer being satisfied with the conveyancing aspects of the transaction. Now, there is case law around what that means, but it is very narrow, particularly when compared to, say, the due diligence condition, which is literally any reason to get out of the contract. Unscrupulous agents will put in a solicitor's approval, and I've seen this happen umpteenth times. They will put in a solicitor's approval condition to an unwitting purchaser because on the basis that this is subject to your lawyer approving the contract. Now, it may well be subject to your lawyer approving it, but there's not a remit there for the lawyer to actually be able to say this is not a good idea to buy this property because you've paid 68% over CV for it. It just means you are able to get out of the contract if there is a serious problem with it, or the title, or the limb. Now, I don't like solicitor's approval clauses for that reason. Limb condition, land information memorandum, issued by council is essentially a booklet of supposedly all the information that council holds up to the date of the limb, and it affords somewhat limited protection in the event council doesn't have their ducks lined up and hasn't provided the correct information. Builder's report, similar, but it's of course regarding the builder's report, the building aspects of the property. Another little interesting tidbit there with the builder's report condition. You need to actually flesh out if you want to give yourself a right to go back and forward with the vendor over building matters relating to the property. With the limb, you're actually able to make what's called a requisition, which is a fancy word for a demand that something which is an issue disclosed by the limb is fixed. You don't have that luxury with the builder's report condition. You're either happy with it or you are not. So you would actually have to depart from the agreement or put the agreement slightly to the side and negotiate with the vendor, but you'd need to do that quite far before the condition terminates, say 5 o'clock, 5 working days from the date of the agreement. Because in this hot market, what we've seen a few times is purchasers trying to bring up some matters disclosed under the building report condition on the eve of or on the settlement date. And if the vendor has another decent offer waiting in the wings, and from an emotional point of view, just cannot be bothered going through with, someone having a go because there's a chipped pergola or a couple of light bulbs missing in the bloody in the add-on bedroom, they may just get the shits with you and can you and get the offer for 10 grand less or 5 grand less because they can't be bothered dealing with nitpicky purchases. So that's another reason to get good legal advice around that. Once the agreement is all afoot, we then check the title. We make sure you have, like the lo and behold, the property isn't landlocked, so you actually have access either directly from the road or via right-of-way. Check all the utilities, check the LIM entries, and then we work with your bank to make sure that you have all of your money drawn down prior to settlement. That is loosely the process at KiwiSaver as well. So we work with the KiwiSaver provider, and a bit of a useful tidbit there is get everything you can lined up really, really quickly with KiwiSaver providers, because they are notoriously niggly in terms of documentation, and it probably causes more hold up than anything else. So you get to settlement, and on the settlement date, you have an ability to raise any kind of issues under a pre-settlement inspection on or before 5 p.m. the day before, the last working day before the settlement date. Used to be you could raise it on settlement date, but the ADLS changed it in their inherent wisdom, which I agree with, to make it 5 p.m. the day before, to stop opportunistic purchasers from raising something right on the eve of tendering their settlement funds in an opportunistic attempt to try and chip some of the purchase price off. So now it must be raised 5 p.m. Or before the day before settlement to avoid that. If, however, you have discovered something in your inspection, for example, there is a clause that says that all the chattels must be in good working order, albeit in the same state of repair they were in, except for fair wear and tear, as as the date the agreement was signed, or there's just literally chattels missing that were actually included in the agreement. You need to come to your lawyer, and you need to get your lawyer to write off to the vendor's lawyer. And they changed the law around the ability to actually leverage any kind of issues like that. Over time, it's gradually become more purchaser friendly, which I really agree with. That's because I was struck when I first started out in 2007 and doing quite a bit of conveyancing. I was struck by how easy it was for vendors to hide behind the law at the time, which essentially said you're paying $1 million or $2 million for this huge asset. Any kind of chattel or issue you have, which is of not really significant amount or quantum compared to this massive purchase, the law is saying we're not deeming it serious enough that we're going to allow any set off. You'll just have to settle and deal with, and then take a shot at the vendor later in the disputes tribunal or the district court. Now, it didn't seem right, and there was a huge amount of cases where vendors would just literally stay mum until settlement, get their money, and then the purchaser, once they probably got into the property, probably thought, oh, it's all too hard. So now the agreement is far better, because you have an ability to actually go to the vendor and their lawyer and say, we have an issue with this. We had one a few years ago, and I hope my client, I know that they listen to this, doesn't mind me talking about it, but they had an issue. It's a bloody interesting one, actually. And it's actually quite a colourful situation. So they had an agent represent that a heat pump, I think it was a Fujitsu heat pump that was won in a competition, was part of the chattels. It turned out that although it was won in the competition, it was actually won on lease, and therefore never actually formed part of the chattels. It was leased from this company, who then, of course, asserted their rights over this heat pump. We, of course, knew nothing about this and weren't able to hold back any funds on settlement. But then we were later able to recover. We were able to later recover from the agent, because misrepresentation has actually been brought in as a head of claim, or widen the ambit as to what can be claimed at the settlement date. Actually, what I was actually going to talk about on that one, that was on the same file, but what actually happened on that file, and this is more relevant, sorry, I got a bit sidetracked because that was such an interesting thing that happened, was that in this file, the there was a retaining wall, and the retaining wall had, according to the agent, minor issues. Whenever I hear an agent say there's a minor issue, the fact they've come forward and said minor immediately puts me on notice. We did a little bit more digging, and it turned out there were serious issues to the tune of 50 to 60,000. And we had to put a lot of pressure on the agent and also the vendor. Now, the vendor was a couple that were actually separating. And so it was very difficult to get any kind of cohesive response out of the vendor and their lawyer and the agent. In the end, the agent and the vendor kind of self-destructed and turned on each other. And the net result in the old days, before the changes to the agreement, would have been that you could not have cajoled the vendor into giving you any kind of compensation or agreeing to negotiate, because, believe it or not, it sounds absurd, there was no ability to hold back funds under the agreement. You get railroaded into settling and then pursuing them afterwards. In this case, we were able to hold back a very generous $200,000 and achieve a resolution in our trust account, not the vendors, which they were originally trying for. We held back that money, and then bit by bit, we ticked off all the remedial work that needed to be done to get these people across the line so that this minor issue was actually sorted out. So that is just a quick précis on the conveyancing process, things to look out for, what conditions are, and how the agreement has morphed over time to give the purchaser a more appropriate set of remedies to be able to ensure that the bargain that was struck, the contract that was struck at the inception of the negotiations, is actually adhered to on settlement.
Just a question out of personal interest, Shane. This ability to hold back funds on settlement to deal with these sorts of issues, that's presumably a discretionary thing. Like, that's a matter of the parties to the contract agreeing how much money that is, and or is that an automatic thing now?
No, it's quite clear. It's quite clever. I'm actually really impressed. I don't agree with everything the ADLS does in terms of their documents, but I'm really impressed with why they come up with it. They came up with this. What they've done is I've said you are to endeavour to agree, vendor and purchaser. If you endeavour to agree, that amount can be held back pending the amount can be held back. The amount can be deducted as compensation and agreed, and that's the end of the matter. That's scenario one. Scenario two is that the vendor and purchaser can agree there is an amount to be held back pending resolution of the matter, and then that you go away and figure out what needs to be done, etc., and it gets set aside. Number three, if the vendor and the purchaser can't agree as to an amount, if they can't agree as to the amount of compensation, or if they can't agree to the amount to be withheld as a retainer pending resolution, a third independent lawyer is appointed. And why it is clever, in my opinion, is it is cost prohibitive to frivolous, vexatious, small-scale, petty behaviour from either purchaser or vendor, or unreasonability of purchaser or vendor as to matters which are not at least, say, $2,000 or $3,000 worth. Because, of course, for a independent lawyer to get involved, they're going to want at least $2,000, $3,000, $4,000 just to start actually mediating the dispute. And no one wants to hand over money to an independent lawyer and pay us lawyers just to hold money and arbitrate. So it actually weeds out all of those kind of baseless cases. Yeah, I've never actually had to refer it. Even in that case I just explained to you, I've never actually had to refer it out to a independent lawyer, and even with that, even that in that serious instance, because I don't think people want to put it this way. Their need to control the purse strings in the process outweighs the baseless, the need to try and win something which deep down they kind of know holds no real wait.
And I suppose there's also that thing that you're more likely to go for a deal you've negotiated that you might not be completely happy with. You might not think it's the best you could possibly do, but it's more in your control than some third party coming in and saying this is what it's going to be. So this is, and this pertains to disputes that have kind of cropped up between binding offer and settlement. So they're things that have come to the to the purchaser's attention after entering into an unconditional offer, but prior to the settlement occurring.
That's
largely.
Right.
Okay.
Largely, yeah. Well, it would need to be after the agreement was entered into, because if it's not, I mean, that the vendor can have an argument in some cases that the purchaser was aware that. So it's usually when they contract on the basis that they were going to get the property, and the agreement has a number of warranties to disclose certain matters, and that's been broadened as well. And by giving those warranties, the implication for the purchaser, which they're able, of course, to rely on in contracting and then settling, is that those warranties put a positive obligation on a vendor to make a statement if there is, if they know that any of those matters dealt with by the subject matter dealt with under those warranties is actually not true and correct. So that's the contractual basis for a vendor not being able to remain silent about something serious like that. The other thing I wanted to touch on, that's why I was going with the heat pump thing, and I kind of went one way and I had to come back because we were talking about the agreement changing and compensation under the compensation provisions and the ability to actually withhold settlement if it can't be dealt with, or a mechanism to settle but then still preserve their rights in a way which preserves the leverage and security. Is a lot of people I've noticed they find out stuff a long time after settlement. It might be 6 months or 3 months or a year. And, you know, from working with yourself, Mike, and with Chris Patterson and James Donkin and some other really good litigators recently, and kind of being involved a little bit ourselves in what I'd call pre-litigation, or, you know, dealing with more adversarial matters, is there is a perception amongst people not don't have a legal or a really adversarial commercial background, they're not entrepreneurs, that once they've bought a property, it is too late and it's too high a hurdle to scale to actually do something about it if they have been really wronged. If it's something minor to do with chattels or, you know, a couple of thousand, you probably are wasting your time, although you could file in the disputes tribunal and hope to get a relatively benevolent adjudicator that pities you because you've been clearly wronged. But I'm more talking about really egregious, serious misrepresentations that have taken place, or silence in the face of something which was really sort of inimical or really at the heart of the bargain to a property. For example, if there was, just making this up, or just sort of freewheeling with this, but if there was a CCC that, I mean, a fraudulent CCC or a whole lot of works that had been done on a property that the vendor never even went to council about, so council couldn't even have known that there was works which would have required a building consent and therefore a CCC to be issued pursuant to that consent. And they just never even told the council, and then somehow and that happens too. And then to have someone go through there from council because of some maybe completely unrelated coincidental events to come through and go, actually, this thing's a pile of shit and it needs to be knocked down, you know, next week before it kills somebody. And what do you do then? Well, you could just go and sort it out, and if you're wealthy enough to do that, you know, sure. But for most people, they're not. And even if you are, if you've got if you have a better understanding about the legal process around what you can do to actually deal with that situation, then I think surely you are better placed to at least consider the option of litigation or even pre-litigation strategy. You're definitely more informed, better off being informed than you are not, if that makes sense.
Well, first a comment about this change to the ADLS. Like that idea of having, I see comments just come up, any tips for buying a new build from a developer, including developers that usually liquidate the company after the build is complete? Well, Shane, do you have any? I mean, my initial thing there is that people liquidating companies is always a problem when you're trying to pursue them in litigation, and there are sometimes means to get the person personally, or sometimes you can go after the agent or whoever's made the representations about the build might not be the same person as the company that sold it to you. But it is generally, it's a problem often, and without looking at the specific facts of a case, it's quite hard to know how much of a problem it's going to pose, is what I'd say.
Let's just break it down a little bit more. Actually, there's a great question, Anitesh. I hope that's how you pronounce your name. And thanks for asking it. It's really good to have sort of interaction with the audience and people coming up with great questions like that. So thank you for making the time, and we'll do our best to give you a good answer. So look, I mean, it's really, really challenging buying properties off the plans. So the first thing you need to do is you need to do your homework as to the quality or otherwise of the developer. What else have they built? Have they got any other properties they've built that have any weather tightness claims? You can search the weather tightness tribunal decisions for them, and you can through a bit of snooping, which isn't that hard these days with Google. Just go and Google the developer and figure out, have they done anything else? The second thing is when you're dealing with the when you're dealing with the agent and you get a sale and purchase agreement, because these developers will have pro forma sale and purchase agreements, look at the how harsh or otherwise that agreement is. If they can change, I mean, you expect a degree of flexibility in terms of the provisions to be able to change some materials in and for margins, things like that. But if you're looking at a contract where they can change everything under the sun, I've seen some absolute horror stories in my time. They want the deposit released straight away, and they have either no sunset date or a sunset date that can only be relied on by the developer and not by you, all these things. And once we start negotiating with these developers, if they are reputable and they have good intentions, it's still a risk, but you can kind of say to yourself, well, they are making some concessions. They do appear reasonable, and on a human level, we trust that they've got good intentions with us. And you can kind of get a feel for, I've been in this game for a long time dealing with these type of situations. You can kind of get a feel for where they're going in terms of how they're dealing with you, the same way you could in any other kind of relationship. So that would be my comments from the other thing as well is, if you can get the developer to agree to hold the deposit, either in their lawyer's trust account. We've been very successful, to my surprise, with that, with some people, and including a situation recently where a sunset date expired and we're able to extract the deposit back, and not without a fight, admittedly, by putting a caveat on the title to the property. If you really fight for it, and depending on the market, you may or may not be able to get that concession, which is a really great concession. It gives you peace of mind if you can get it. But the other comment, the second sort of limb, so to speak, of your question is around liquidating. Look, that's always going to happen. I've actually got an apartment of my own. We're going through the courts at the moment with some issues, thankfully not too major, but with the balconies on an apartment I own. And the issue there is that the developer, of course, has liquidated that particular company, even though they're doing other developments around Auckland. And while that's frustrating, in our case, we have, the council has given arguably a CCC where they shouldn't have in respect of certain works. So, like every other liquor building litigator, we're taking a pot shot at the council before we even look to the developer. So the developer liquidating thing, that's always going to happen. It shouldn't be in the forefront of your mind when you're actually looking at buying things off the plans, because that's probably inevitable. It's more a question of the quality of what they're doing, their reputation, and also some sort of safeguards in the contract, such as holding the deposit back if you can.
Yeah, I mean, I think what comes out of that is effectively, you want to be doing your due diligence on the front end, because when you get into a situation where you're dealing with a problem there, all bets are off, and your chances of recovery are often not particularly good. Whereas on the front end, by exercising some caution, making sure to ask the right questions, get the right advice, you can usually steer clear of the obvious risks at least. That ADLS change, Shane, like, as you'll know, who's got the practical leverage is a huge thing in any kind of commercial dispute, even before it becomes litigious. So that holding back of funds puts a person who ends up in a dispute over a residential sale before the settlement date in a significantly better position than someone who has a dispute sometime after. Particularly because that ability to have the funds on hand for the purpose of the dispute, it provides a lot more certainty around recovery, and it probably also opens up. Is there anything actually? That's a question for you, really, Shane. Is there anything to dictate how a dispute that arises pre-settlement is dealt with? Like, is there presumably there's a contractual mechanism for that, or it's been a while since I've had to look at an ADLS S&P.
Do you mean, does the agreement actually map out how that is dealt with?
Yeah, like is there an arbitration clause or something, or is it still the case you've got this money there on hand that's been earmarked for a dispute, but you've still got to run off to court and take claim for misrepresentation?
My view is yes. I actually can't remember off the top of my head, because I've only ever had to get as far as getting that money held by us a couple of times as a purchaser's lawyer. I've never actually had to invoke the clause in as far as putting it with a stakeholder solicitor until the dispute is sorted out. So I actually couldn't tell you off the top of my head. Yeah, I'm not sure. But just actually having that, like you said, Mike, just being able to withhold. I used to be horrified when I was a junior lawyer, instinctively doing heaps of conveyancing deals where I used to work, like heaps and heaps of them. Excuse me. I used to be horrified by how both vendors, when we were acting for purchases, but also our clients when we were acting for some of these somewhat dubious property trader types, how that it was very normal as a vendor and their lawyer, whether that was, like I said, you or you're on the other side of it, to just actually sit on these letters from purchasers' lawyers setting out, say, 8 different things, 2 or 3 of which might have been reasonably significant that were wrong. And you'd just sit on these things. That was your instructions. We obviously bound by our client's instructions. And coming up for 4 o'clock, send this kind of testy email saying you're aware that there was a clause that used to say, even if there is a dispute other than for errors of misdescription of the title, you must settle in full without deduction, and the right for compensation under this clause does not defer the obligation to settle. So we just spit this precedent letter that we had out, and sure enough, these poor people at 3:56, whatever it was, before 4 o'clock, before a whole weekend of penalty interest was due to accumulate at 4 o'clock, would reluctantly, through gritted teeth, send all the money through, because they knew that the way it all worked was that they'll be paying penalty interest, even if they might have had 5 or 10 or 15 grand worth of damage. It was just not right. So I'm super glad, because while I get the logic that while you are, say, spending 1.5 million or a million or whatever it was back in those days for the average house in Auckland, I get the logic that they didn't want people to be able to horse trade over what was seen as incidental or ancillary matters. But at the same time, it just felt far too balanced in the favour of a kind of educated, opportunistic vendor over a kind of maybe guileless and, unenlightened purchaser. It just felt wrong. And people did it all the time, particularly the property trader types.
Mm-hmm. I've actually had about 6 or 7 years ago, I thought that, and I'm very glad I didn't, because Christchurch has been a pretty weak market ever since, but I thought there was an opportunity in Christchurch to buy property because prior to the earthquake it had been on par with Auckland, more or less, historically, maybe 10 or 20% lower values. And after the earthquake, you were looking at more like half to a third. And so I thought, I'm going to buy an investment property down there. And I couldn't be asked flying down there, so I put an offer in on this place based on a Trade Me ad. And I wasn't silly enough not to. This was back when you could use subject to finance as a way to wriggle out. So I flew down to look at it, and lo and behold, what had appeared to be from the pictures weatherboard cladding was actually that bloody horrible plastic faux weatherboard shit they put over that's rotting out. And it was and there were a number of other ways that was materially the ad, how it was described, the photos that were taken represented it to be a much, much better house than what it would actually turn out to be. And because I could wriggle out, I never had to take that down a legal route. I did go after the real estate agent with the Real Estate Agents Authority, just for, I thought it'd be interesting to give that a trial run and see how much that had in the way of teeth. And the answer.
How did that go?
I got a lovely apology. It was really
you did well.
Yeah, well, that's I gather that's quite a good outcome in that forum. Like, I never expected or felt I particularly deserved any financial recompense, but I drummed up a thing that I'd flown down there and I'd wasted time, and just because I was intrigued to give the process a bit of a run through. And I did think that the way that they had marketed this property was pretty shocking. And obviously that would have been cured in most cases by going and looking at the thing. But that they were comfortable to sell it to me knowing that I hadn't, when they knew how materially different it was from what they'd represented it to be. But all of that's to say, only that I kind of appreciate that these things occur and how they occur. I think people that end up in a situation where they have bought a thing, settlements occurred and they've only discovered the thing that was deficient sometime after, maybe quite a long time after. Like I've got friends in the development and investment kind of game that often they'll do things that are, dodgy in a minor way, like they'll have changed a wall without getting consent, or put a toilet in without getting consent, or and sometimes not being too upfront about notifying a vendor of that. But say you discover something and it really is quite a serious issue. And I'd say if you're going to think of litigating, it has to be like really quite a serious issue. It's got to be, you're talking 100K plus really for it to be, unless it's so clear cut that it's worth the risk. Because that's I'm getting a bit circuitous here, Shane, but the point is... No,
it's good. It's great. Keep going.
To go up to court on misrepresentation, like you need to, if it's a district court thing, you're probably looking at stumping 15K minimum. If it's a high court thing, 60 to 80K. And if it's a really, really clear thing where, you can go to a litigator and they say to you, look, there's just almost no way you could lose. You're never going to get quite that from a litigator. But if they're pretty bullish about it, maybe it's worth floating that money for an amount that's sort of equal to or less than. But generally speaking, you want the prize to be significantly bigger than both your litigation costs and your exposure to the other side's litigation costs.
The other side of it, just playing devil's advocate on that though, the other side, because one we've been working on recently, and we just have a barrister helping with us now, but it's interesting because say it's a 50K dispute, right?
Mm-hmm.
But say that morally and ethically, it really is on the side of the purchaser. And if the agent was involved and you write off to the agent's lawyer and make an allegation against them, they get their lawyer to write back to you, which means they're worried enough to have ponied up $1,500 to $2,000 to actually get the lawyer to look at it and try and get it to go away with another letter, right?
Yeah.
Then if you go back and you say, look, you've got to be reasonable here. This is on the facts, reasonably easy to prove. And on the balance of probabilities, a judge is probably going to say, I can kind of see how this happens, and you are going to be in for some kind of award. Now, if the lawyer acting for the agent is doing their job and they're competent, they're going to say to their client, look, Daryl, I know, look, mate, I know thought I could get this to go away pretty quick with a letter, but these guys aren't going anywhere. They're obviously well-resourced and they have capable counsel acting for them. And if they run the gauntlet and they file ordinary proceedings in the district court, you're obliged to go off and defend those. And that's going to cost you 10 or 15, or like you said, 12, 15 grand with me, Daryl. And you're going to have to pay me. And because their claim is not so frivolous or vexatious or baseless that the judge is going to throw it out and order costs against the purchaser, there's a very high chance that costs are going to lie where they fall because with the parties, which means you're out of pocket anyway. So a purchaser in that position could be well advised to keep niggling the agent, because the agent may just turn around and go, you know what, fuck it, I don't really agree with this and it's marginal, but I don't want to pay my lawyer down in Shortland Chambers another $1,300 on top of the $2,800 I've already paid him, and I'm going to give you 12 grand to piss off. That's
that's very good devil's advocacy, and a clarification I can make off the back of that is, of course, litigation's not binary. You don't go from not litigating to the end of the process and getting a judgment. There's a big road in between those two things, often months and months of time. So generally speaking, if you've got a case where, frankly, you've got a terrible case, but you're trying it on, you might not invest any more than your own time in writing a few letters and getting a bit obstreperous. If you've got if you don't have a great case, but it's kind of a bit better than that, you might get your lawyer to write a letter for you. And as you progress and the costs escalate, so, by the time you're putting proceedings into court, your costs have escalated quite a lot. And at that point, you've got to be thinking, we'd have a pretty good chance of winning this. We do have a serious claim. And as you've rightly pointed out, at that point, there need not be money involved that would justify running a full litigation, because the other side has all of the same calculus to make that you do. So they're looking at it and they're going, God, these guys have a serious claim. Yes, it's only a claim for 50K, but they've just filed proceedings. If we're going to have to file a statement of defense, we're going to have to go down this path with them. If we both go down this path, we're probably going to lose, and we'll have to pay that money and pay their costs. And that's why litigation is a very good process for driving settlement. It's why most things actually settle. And it's also why often if you want to drive a settlement, you need to commence proceedings before you get any real traction, because it's that point that shows you're serious and makes the other side really confront what their worst situation looks like. So that's all very true.
Yeah, that is very true. In my relatively limited amount of experience firsthand, but reasonable amount of indirect experience dealing with these matters and piloting them somewhat for some of my more commercial clients, is that whole filing of proceedings, sometimes threatening it, but sometimes the actual filing of proceedings is where the rubber hits the road in the eyes of the other party. So they go, okay, shit, they're actually going to get another barrister who specializes in this. That barrister's taken it on, and they're going to go and spend some time and money to get that barrister to put together these proceedings, which means I'm going to now have to go through all the hoopla of engaging my lawyer to go off to court. That can be quite a telling moment for the whole litigation, can't it?
It can. And just to point there for the viewer's erudition, something that, lawyers like yourself, Shane, who do a lot of pre-litigation work, well understand is that, of course, you can't, in a letter as a lawyer, threaten to file proceedings if you don't intend to go through with that threat. And what that often means, because lawyers are naturally very risk adverse, is that unless they've got quite clear instructions, if this doesn't happen, you go to court on Monday and you file, they will give you their bully letter, and they'll end it with something like, rah, 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 scary, scary, scary. If you don't do this, our client will look to their rights, or will, reserves the right to exercise all of their legal rights and remedies, or there'll be some kind of line at the bottom that means something other than we will file. And it's as a lawyer, when you get that, it's always a good indication, okay, these people aren't really as prepared to do this thing, or as confident that they want to do this thing as they might be trying to appear. And that's just a thing to be mindful of if you get a letter like that as a layperson, and you're wondering what to do about it. I mean, often
we always I go as far as copying the barrister and say we'll file.
Yeah, even when you aren't certain that you will.
Oh no, I want to be certain.
Yeah, like that's the thing. If someone's really going to sue you about something, like that's it.
There's a good saying that Brent Norling, my friend Brent Norling taught me. Brent's taught me a few things, but one thing he told me once, we're talking about something, getting money out of an insolvent party, and he said, "Look, Shane, you don't make a threat you're not willing to follow through on, because you just end up looking like a twat. If you say we're going to do this, and then a week passes, nothing happens, you've really lost the whole battle. You've lost the whole battle and the war, because you've just basically they've called your bluff, and they haven't even had to do anything. They've just watched you make a twat of yourself. So no, we certainly won't be saying we'll file and copying a barrister if we're not going to."
Well, that's actually it's a thing that I never really enjoyed deadlines at university, and it was a thing that gave me great pleasure when I left and entered the profession, is my instructing partners at the time saying, look, when you get letters that say, please do X by, close of business Friday, in an adversarial situation, unless there's going to be unless you really believe there's going to be some significant downside to not complying, never comply. Even if you quite happily could reply to their letter by Thursday that week, reply to it Wednesday next week, because it deprives them of power, it deprives them of a sense of control, and it's psychological.
That coupled with the whole recouching of the dispute or the subject matter at hand in your terms as well, as opposed to just replying to someone's letter. You know, they set out 8 different things and you just ticking them off. That's not a strategy. Just writing back to someone. You certainly don't do it within their time frame, and you certainly don't do it on their terms. 100%.
Because it's amazing what can be achieved by being the party that sets the agenda and that sets the strategy, and that's proactive rather than reactive. Like, it's something that's easy to, you know, even as a lawyer, when it's just a back and forth about the merits of a particular issue, it's easy to underestimate how valuable that can be.
And almost nothing that is written in a knee-jerk fashion straight back to someone, the same way in an argument with someone out of a professional context, said without proper foresight, is almost never is completely impotent anyway. When you get something straight back, you go, ha. No, it's never a good sign for the person who's just written straight back to you. No,
it's not. Is there anything, Shane, that you think we should say or talk about with respect to the kind of the relevant sort of misrepresentations that can arise in a residential conveyancing situation that someone might want to sue for? What the grounds would be that would allow them to?
What did you have in mind?
I mean, I'm conscious we're kind of coming up on an hour, and that's a big discussion to be had. But, you know, I guess...
Well, why don't you start traversing it a little bit, and then we'll see how we go. If it's too boring for everybody, we've still got some willing participants. Yeah.
Yeah, and interrupt if it's... I mean, it's for people that are watching that have watched us before, it's stuff that we've covered in other contexts. But effectively, with misrepresentation, you've got the Contract Commercial Law Act and you've got the FTA. Now, I'll leave the FTA to the side for the moment and just talk about the Contract Commercial Law Act, but a lot of it's quite transferable. Under the Contract and Commercial Law Act, you can either have a contract cancelled, or you can go for damages. So you've sold a property, you can either unwind the sale, which is effectively you get your money back, they get their house back, or you can keep the property and you can get damages for whatever the usual way that would be calculated is what would the benefit you gained have been if the misrepresentation had been true. So what's the difference ordinarily between what you paid and what it's actually worth due to this horrible defect that you've discovered? So a misrepresentation has to be something that's communicated to you. Doesn't matter how. Obviously, if you want to have a written record of it, like, it's not going to be much of a case if you're saying, this is what I was told orally. You can go there, but you want to have some evidence, which is why when you're dealing with respect to the buying of anything, particularly a large transaction, any kind of thing you're told about it that you consider meaningful, in the sense that it's one of the things that you perceive as a reason for buying this thing, you want that in writing. Often it'll be, often it won't be things like that. I think in a residential context, it won't be like you're told it has something and it turns out it doesn't. I mean, sometimes that happens, like a heat pump example is a bit like that. But I think more often than not, it'll be that you buy it and you find that it wasn't quite what met the eye, that there'll be some sort of structural problem or water ingress or something about it.
We're actually dealing with one at the moment where a guy was told that a tree on a neighbouring property that had a material that was going to be chopped down, and the question of whether or not that tree would be chopped down or not had a materially significant effect on the views that this apartment would get, and he bought a higher level apartment because of these views. And we're in a position where we're trying to argue against both the developer and the agent that, but for the representation as to this this action being done, which the agent and the developer are both allegedly involved with, but for that, he wouldn't have paid the consideration he did for the contract. Now, that sits on all fours of what you're talking about, and that's quite an interesting and challenging proposition, particularly for our guy, because there's no written evidence of it, although it is quite easy to piece together how it did happen, and you can tell from some of the letters from the lawyers that something has happened. And secondly, there was nothing in the sale and purchase agreement around it, and I thought reason quite astutely pointed out in some of our correspondence that while that is unfortunate for our client, and while that certainly does not help his position, that is not tantamount to saying that it is not a determinative of whether or not the misrepresentation did in fact take place or not. There's no nexus. It would help us, but it didn't happen. But that doesn't mean the misrepresentation didn't happen, if that makes sense. So while it would have been prudent, otherwise the law would become overly prescriptive and say, well, because this formality wasn't observed and this gross misrepresentation happened, you have no cause of action. The law doesn't work like that, as we know. It's just unfortunate it wasn't dealt with in a better way.
It's definitely, obviously an oral representation can be a basis for a claim, but you're definitely on much stronger territory if you have something you can point to than if you have to go into court and simply say, well, this is what was said. And, realistically, people, even under threat of perjury, are often quite willing to say, well, look, that's not how I recall it. I never said, I might have suggested that, this view would always remain, but I never represented that I knew that to be the case. Or, they'll often try and slip the noose on that sort of thing. But you're right, that views, that's a common one where it is a positive representation. Often people will buy a thing because it has a particularly nice aspect. Yeah. Another one I've had recently is the person who purchased a farm, bare farmland, on the understanding that they could build a house. There was a house site that they could build a house on, notwithstanding that the farm was on a floodplain. And, we haven't got deep enough into it yet to know quite where we'll go with it, but it's interesting because we've got the agent saying it, the vendor saying it, and the council saying it, and all in writing, which is wonderful. So
fabulous.
That's one of those good times when you've got multiple targets and you've got ample evidence. But so that the key thing is you have something's told to you, it isn't true. It means that the bargain wasn't what you bargained for. You've received less than what you expected to. Often you'll be able to point to a diminution in value. You probably want to for it to be a serious claim. And then you have to be able to argue that the misrepresentation induced you to enter the contract, that it was I'm mincing my words here a bit, but
no, you just keep going. It's good.
That it was an essential term, effectively, that if you had known that this thing was different to how it was presented to you, you wouldn't have paid what you paid or entered into the contract at all. And if you've got a scenario like that, then it's certainly worth seeking advice on, because you'd be surprised on what can be done.
Yeah, and that's the point I was trying to make earlier, and I was really beating around the bush about it as well. It's quite a complicated subject or point to make, but I think, I think what Mike and I are saying, to sum that whole point up, is intuitively, if you think that you've been We back?
We had a good run there. We got just past an hour.
We're still going.
I lost you at intuitively.
Yeah, so intuitive. If you purchase, so what is a contract? So let's just use sale and purchase of land as an example. So you sign a contract to buy a property for $1 million. It's conditional on certain things happening, but it also has, in the general terms, under the ADLS agreement, a series of warranties where the vendor warrants that certain things are true and certain things have or have not happened. For example, if works have been done, a CCC has been, in the Building Act, has been complied with, the CCC has been issued. Also warrants that there's no misrepresentations or any other things, and there's a positive duty under law to actually, for a vendor in that circumstance, to advise the purchaser if there has been something which intuitively, bringing it back to the viewers so it actually has some sort of common application, intuitively you should know. Give you an example. A friend of mine we're acting for over the weekend, she had a situation where she needed to get some consents for a cross lease for some unauthorized works at deck, and we got 4 consents through, but unfortunately one of the consents had a whole lot of other kind of dirty laundry over this alleged issue with the fence, and having all the shrubbery up against it and needed to be redone. And she was like, "Oh, what do we do here?" And I said, "Well, we could just say we've got the consents and then on settlement hit them with the bad news, or we could just be open and upfront and say there's no basis to actually cancel the agreement or do anything about this, but we want to be open and transparent." To her credit, she went for the second option, and she got good karma because it ended up not being an issue with the purchaser, who had actually been quite titchy up to then about certain things. So I guess where I'm going with that is that the contract sets out, it's not just an obligation to hand over the property once the money's paid. It's actually a bundle of rights and obligations which have the effect of, in theory anyway, or in the normative sense, have the effect of making sure that the purchaser gets what they paid for. So they pay for a property without all these issues, which the vendor has a duty to tell them if that is not the case, because on the face of it is the case, there are no issues, right? So if you are in that situation, the property is the example, it could be a car. Shafraz, I don't know if you've met Shafraz Khan, Mike, another friend and colleague of mine. It's quite a funny story. He bought some sort of Audi, a Q5 or something like that, from the dealer, and he paid. It had this sort of like automatic, driverless car and some sort of other functions on it. He got in it and he drove it down the road, and he got about a K down the road and he realized that it had none of the features on it that he paid for when he imported it. So he drove it straight back to the dealership, and he said to the young guy who'd sold it to him, "Hey mate," he said, "This car's not what I bought." And the guy said, "What do you mean? Of course it is. It's an Audi Q5." He said, No, mate. This thing, these are all the specs that you told me it would have." He pulled an email out of his suit pocket and to the guy, and he goes, "Do you know how many of these things it's got?" And the guy said, "How many?" And he goes, "0." He goes, "I'm not buying it. It's not the car I paid for." And the guy said to his manager, he went to his manager and he came back, he said, "We've never had anyone do this before." And he ended up getting another car, which is actually, I don't think had all the specs he wanted, but a lot better than they tried to give him. But the point is, intuitively, if you're not getting what you paid for, then you could have recourse against the person that sold it to you in certain circumstances. And the bar to get to righting that wrong might not be anywhere near as prohibitively high as you think it is. So it's always worth talking to us or another lawyer about what possibly you could do to sort that out, rather than just resting on your laurels and going, "Oh, well, that sucks and they'll get their karma in this life or another life." If you see the world that way, you might actually be able to do something to recover some of your pingers.
Yeah, very true.
Yeah. All right, I'm exhausted. Talk misrepresentation. I think I've done more legal speak in this hour, Mike, than I had to do all day.
I wish I could say the same. This has been a day with many fraught client phone calls, but no, I think that wrapped up nicely.
Yeah, good. So I'm going to hit the nuke button, and we will see everybody next time. We had quite a good turnout tonight, so thanks for joining us.
Oh,
Cheers.
Great. Thanks, Shane.
See you, mate.